Good afternoon. I'd like to warmly welcome you to this OxFirst webinar on Canadian damage calculations and IP infringement cases. I have the great pleasure of presenting to you today Professor Norman Siebrasse, who is a professor with the University of New Brunswick in Canada. Professor Siebrasse has a strong interest in the interplay of intellectual property and commercial law. He specialized on patent law and has, in that area, but especially focused on pharmaceutical patents and pharmaceutical cases, which reflect actually the market situation in Canada at the moment. He's also of a blog, which I very strongly encourage you to sign up to because it's a really good blog. The blog is called Sufficient Description. And I'm really happy that he's presenting here today and gives us insight on how the system works in Canada when it comes to calculating damages for court cases. And I think he will not just give you a general description of what is going on in Canada and how Canadian law ticks, but he will also bring a decent academic, criticize it, and illustrate shortcomings and show where things could probably work much better than they currently are. So for those who don't know us, OxFirst has been up now for 11 years. OxFirst was founded by myself and another academic from the University of Oxford, and I was working on intellectual property, and we believed that the work we were doing at the university had practical application and that we could bring our ideas and creativity on intellectual property management and intellectual property governance structures closer to the market. And so we embarked on that adventurous journey of starting a company that offers IP law and economic research analysis and studies, expert testimonials, expert witness opinions as it relates to patents and copyright mainly. We'd be open to trademarks, but so far it hasn't really come up yet. And in this over 10-year-long journey, you can see I got gray hair, but it was clearly adventurous to learn so much from so many different companies, countries around the world, and just help people understand better why intellectual property is exciting and how you can better come to grips with it. So as part of that, we run our webinar series once a month to give people new ideas and food for thought about IP. And if you're interested in giving a talk yourself or presenting, please let us know, get in touch with us. You find our contacts on the website. Other than that, it's important to mention that we are running a conference. We all hope you'll be joining. We'll run the 7th Intellectual Property and Competition Forum, this time in Munich, in end of June, in the week of June 20th. If anyone is interested, we're going to talk a lot about standards and patents. With all of that being said, I pass the floor now to Professor Siebrasse to present his research on damage calculations in a Canadian context. Thank you very, very much for joining us today from Canada.
Thank you, Raya. And I'm just going to get right into it. Can you all see my screen now?
Yes.
All right, and all I've got is the Zoom thing minimized. All right, so thanks everyone for joining. I know Canadian patent law it seems like a pretty niche topic. Who really cares about Canadian patent law? But I hope to persuade you there's some interest really in the treatment of the so-called non-infringing alternative, where in the recent years, really since, well, the past kind of decade or two, we've seen quite a few cases on this issue that are kind of interesting. Well, and that doesn't persuade you very much, I'm sure, but we'll hopefully I will be able to persuade you as we get into it. So I want to give you a little bit of background to start with on the Canadian litigation system. Almost all cases are heard in the federal court. The federal court has about 40 or so judges, but only 6 of them regularly are assigned to patent cases. So they have developed considerable expertise. It's not quite like the UK system where the the patent court judges were themselves patent practitioner. There's usually only one or two Canadian federal court judges who actually practice patent law. But the judges who are assigned to the patent law cases, of course, develop a considerable expertise in the area, and they're regularly assigned. So it really is a specialized bench. The cases are routinely bifurcated between liability and monetary remedy, and often settle after the liability phase, of course. And so liability would be validity, infringement, and injunctive relief is also decided in the initial liability phase, but then all the monetary remedies are not invariably, almost invariably bifurcated, not always. So often they settle, and of course, just certainty in the law is very important to whether or not they settle. The market, the analysis can be very sophisticated. There's a lot of pharma litigation. Certainly, the cases that actually go to trial and that are reported are overwhelmingly pharmaceutical. The damages calculations are quite sophisticated. A lot of very specialized models of market entry. How long would it take for the first generic to come in? How long would it take the second generic to come in, and so on. So it's a reasonably sophisticated bar as well. And of course, the forensic accountants are also know what they're doing. Damages can be very substantial. So the most recent case was on the order of 500 million US. Now that decision that does go directly to this issue of the non-infringing alternative, I'll be talking to the Supreme Court of Canada, will be heard sometime this term. I'm not sure exactly when. So 500 million, but the leading cases, there are about a half a dozen leading cases that have developed this concept of non-infringing alternative, and the damage awards are on the order of $100 million. So now, of course, not all the cases are that substantial, but that just gives you an idea that there's significant amounts of money at play here. The damages in Canadian litigation, the monetary remedies include damages. This is standard, of course, lost profits or reasonable royalty. Also, an accounting of profits, which is to say is disgorgement of the infringer's profits, are permitted. Kind of a common law equitable remedy. We're based on the UK system. But what's a little bit unusual perhaps about the Canadian system is an accounting is routinely requested and routinely granted. So it is in principle a matter of discretion. There have been a couple of cases where the judge has said no, but by and large, the patentee who wants an accounting of profits can get it. We also have a patent linkage system similar to the US Hatch-Waxman system. So there's no, I understand in the UK, there's kind of clearing the way doctrine. Generic wants to enter the market, and they have to kind of fight things out on interlocutory injunction, or sorry, declaratory judgment application, and they'll be enjoined from entering. Without that, we don't have that. We have a patent linkage. Generic wants to enter. They basically have to notify the patentee and address all the listed patents. And the important point from the remedies point of view is that there's an automatic 2-year statutory stay. So the generic wants to enter, they notify the patentee says, no, you'll infringe. Statutory stay for 2 years, essentially originally modeled on interlocutory injunction. The monetary part comes out because if the generic wins at the end of that, the patent was invalid or not infringed, then the patentee is liable for the full damages caused to the generic by having been kept off the market for those 2 years. Exactly parallel to damages on the cross undertaking on interlocutory injunction in UK law. So these, many of the cases revolve around, we call them Section 8 damages, but it's damages on the undertaking in effect. And the damages can be very, very substantial, 100 million in the bigger cases, 100 million plus. The same causation principles apply for all of these monetary remedies, whether it's an accounting, it's the damages. Damages is the damages caused by the infringement, and accounting, it's the profits caused by the infringement, and the Section 8, the undertaking, it's the losses caused by the having been kept off the market. Our system, we don't have any statutory guidance as to the actual damages. It's monetary remedies based on common law principles, in particular tort principles. Canada still has a tradition of looking a lot to the UK, and so it's certainly our early principles were based on UK law, although we've deviated in this regard in particular, as I'll get to in a minute. So the general test is just as familiar. I take it it's familiar to everyone. Kind of but-for test for causation. And this is our general tort law test to show that the injury would not have occurred but for the negligence of the defendant. And of course, in the patent context, it's not negligence, it's but for the infringement. And the standard measure is, well, you have to look at the difference between the position the victim, the patentee actually was in, and the position they would have been in but for the wrong, that is to say, but for the infringement. And it's that difference that is the measure of damages. So this was recognized in the leading case of Monsanto and Schmeisser involving genetically modified canola, Roundup Ready canola. Canola is an oilseed plant. It's very, very big money out in Western Canada, one of the major crops. And the Supreme Court of Canada restated this traditional tort approach in that context by saying the preferred, it was an accounting of profits case as it happened, and said the preferred means of calculating accounting is differential profit, which is to say the difference between the defendant's profit attributable to the invention, which was infringing, so attributable to the profit attributable to the infringement, and the difference between that and the profit the defendant would have made had he used the next best non-infringing option. So the actual language there is non-infringing option, but now it's standard to call this the non-infringing alternative. So our standard measure of damages or an accounting causation generally is the difference between the actual position and the position they would have been in but for the infringement, and that difference is the profit to be disgorged or the damages, And really, this is very similar to the application of the tort law crumbling skull doctrine. So the crumbling skull doctrine says, yes, I hit you with my car. Yes, your back is thrown out as a result, but you had a degenerative disc disease. Your back would have gone out anyway. And that's the thrust of the argument in these non-infringing alternative cases, is to say, yes, I infringed. Yes, I competed with you. Yes, I took away your profits. I caused you loss by selling infringing goods in competition, but I would have competed just as well even if I hadn't infringed. So this really the only, and that can result, of course, in a substantial lessening of damages. So the patentee, sells, 1 million pills at $10 a pill for $10,000. Generic comes in and takes half of that, and they say, well, I lost $5 million in profits. And the generic says, no, I would have sold just as many pills at the same price by using a non-infringing process. So your damages are actually zero. Your damages caused by the harm, even though, in fact, I took 5 million of your market by selling an infringing product. So that's kind of the part of it that's counterintuitive. The defendant, so that's the extreme example. The defendant actually sold infringing product, is able to prove they would have been able to sell non-infringing product at the same price and taken that 5 million in sales even without infringing. In that case, damages will be zero, notwithstanding that they actually sold 5 million of infringing goods. So that's the part that's a little counterintuitive. But as I say, this is really, it's analogous to the crumbling skull doctrine. Yes, I hit you. Yes, your back's gone out, but you had a bad back. You would have been, your back would have gone out soon enough anyway. It's not always reducing the damages to zero, and typically it's not. In some unusual circumstances it is. Typically it results in some kind of reduction of damages. And really the twist from the NIA, non-infringing alternative defense or approach, is it takes account of harm to the plaintiff from the infringers, the defendant's alternative action, what the defendant might have done, as opposed to the traditional crumbling skull, where the crumbling, it's almost like saying, yes, I hit you with my car and caused your back to go out, and that was tortious, but I could have hit you with my bicycle and caused your back to go out, and that wouldn't have been tortious, and you would have suffered the same harm. So that's kind of the twist. The crumbling skull is you would have suffered the same harm anyway from some third cause. The non-infringing alternative says the infringer, the actual defendant, could have caused you the same harm by some non-infringing mechanism. So let me give you some examples to kind of motivate that. A really basic example that maybe is not going to be very surprising, or I hope it won't be. Let's say we've got a farm equipment dealer selling two grain augers, and they've got a standard grain auger that's, the cut rate price, and a premium grain auger that's got all sorts of bells and whistles, including a high flow auger. And the high flow auger is patented. So we go to litigation, the patentee wins the infringement action, and the defendant is able to prove, yes, I infringed, but even if I wouldn't have infringed, some of my customers would have bought the standard auger. If I wouldn't have been able to put that high flow auger on there, some of the customers say, wow, bummer, you don't have the high flow auger, but I'm not going to go off and buy from the patentee. You're my dealer, you're giving me good service, I'm just going to buy the standard auger. So this, I think, is would not, so in that case, the patentee can't get lost profits because they wouldn't have made the sale. At best, they can get a reasonable royalty. So this, I think, is pretty, well, it's pretty standard in US law and Canadian law, but really it's a form of non-infringing alternative. We tend not to think about it that way, but it is. The non-infringing alternative is I would have competed in your market by selling the unpatented goods, and that's harm caused by the defendant to the patentee that would have happened even but for the infringement.
Could I ask you, how would you prove that? You can easily say, wow, they would have bought from me anyway. How do you show that?
Well, typically by, it depends on the nature of the goods. So market allocation calculations are acceptable when you've got a large, so you can just do kind of market share calculations. If you say, yeah, so there's some, for large scale stuff, it's market share calculations. For smaller things like grain augers, there was an actual grain auger case, and they actually get evidence from individual buyers. The individual buyers come in and say, yeah, that grain auger wasn't so important to me. They can do survey evidence asking how important the grain auger is. So this is actually in US law, to my understanding, is a real problem where lost profits are very often denied on the basis that because if it's a damages case, it's for the patentee to prove that they would have made the sale, that on the patented good. It's not for the infringer to prove that they would have been able to sell the standard one. It's for the patentee to prove that they would have made the sale. And so that can be difficult because they say, well, I was selling the same stuff, and the infringer says, well, yes, you were, but that wasn't what was driving the sales. So, but the nature of the evidence can be market share evidence, or it can be individual evidence from particular buyers, just depending on the nature of the market. So that's pretty well established. Certainly in US law, way back to Pando is the leading case, and Canadian law is much to the same effect. So the point is that that's not very surprising, but when you think about it, that's really a non-infringing alternative. Now, the leading case in Canadian law is Monsanto versus Schmeisser. And this is significant because up until that point in an accounting of profits case, I don't want to go into all the ins and outs, but the way the law was understood is that the patentee was entitled to the infringer's accounting profits. That is the difference between the revenue and their cost. So there was no question, there was no consideration of, well, I would have been able to compete as well anyway. You sold infringing goods for $5 a pill. You made a revenue of $5 million. It cost you $1 million to actually make the pills. The difference, $4 million, that's your profit off those pills. So a straightforward accounting profit conception. Now, this was, so that was the traditional understanding. This was rejected in favor of the differential profits approach in Monsanto versus Schmeisser. And this also rejected the old leading case of United Horseshoe out of the late 19th century, House of Lords decision, United Horseshoe, that essentially rejected the concept of a non-infringing alternative. And this is kind of Lord Halsbury said, what does it matter? What does it matter if it is ever so much established that the loss which the pursuers, was a Scottish case, which the pursuers have sustained by the unlawful act of the defenders might also have been sustained by them under such circumstances as would give the purchasers no right of action. So he's saying, what does it matter if they could have competed lawfully? Your lordships have to deal with the facts as they exist. So that was the House of Lords decision. That had kind of been, that was the understanding of the House of Lords decision, at least the common understanding in Canada is that it excludes consideration of these non-infringing alternatives. And I'll just compare this with the Scottish First Division Scottish Court of Session that was on appeal, where it was Lord Adams said, I've come to the conclusion that the patent, the argument is it wasn't very good. It was a cost-saving thing. It didn't really save. The saving is so immaterial that I have no doubt that the defenders, without its use, would still have manufactured their nails and competed with the pursuers just as they are doing now. So that was the Scottish Court of Sessions, and that's essentially, that was rejected by Lord Halsbury, saying your lordships have to deal with the facts as they exist. What does it matter that they might have competed? And that United Horseshoe approach has now been expressly rejected in Canada. It's not the law. All right, let me get to the example. What happened in Schmeisser? Schmeisser was a knowingly planted, patented herbicide-resistant canola seed, that is to say Roundup-ready canola. He claimed that the canola blew into his fields. He noticed this while he was spraying with his conventional crops, that some of the canola didn't get killed. So he collected this, took the seeds, and got enough of a seed crop to plant entirely with Roundup Ready canola in the next season. So it was uncontested that he knowingly entire field with patented canola. But his claim was that he treated it like conventional seed. He was just doing it as a matter of principle. There's a movie out now about Schmeisser, where he's a little guy standing up to big bad Monsanto, all that kind of stuff. I was just doing it as a matter of principle, anti-GM, whatever it is. So he says, I never took advantage of its herbicide-resistant properties. You have to spray the herbicide a little different schedule. So on that basis, and now I'll say, he said that it went all the way through the courts on that basis. What had really happened is we don't know if he did or he didn't. Under the law as it stood, Monsanto didn't think that they had to prove how he treated it one way or the other, because they were just going after his accounting profit. It sold for this much, it costs you so much, we get the difference. So they went on the basis that he had not treated it, especially he hadn't taken advantage of the properties. Whether or not that's true, we don't really know. So on that basis, the differential profit is zero. Yeah, he made a profit selling an infringing seed, but he treated it just like conventional seed. He got the same yield as conventional seed. He had the same costs as he would have had as conventional seed. So he would have made exactly the same accounting profit with conventional seed as he actually made with the patent seed. The difference is zero. And that's what happened at the Supreme Court level. Supreme Court says, well, differential profit is a preferred method. Differential profit is zero, and therefore, yeah, you win. It was infringing, but the damages are zero. Now, I'll say, then the infringer's getting a free pass. This is terrible. Well, the same facts happened in the subsequent case, Rivet, and Monsanto by this point realized that they had to prove that it was used in an infringing manner. They did. They got substantial damages. And it's not to say that that somebody who uses a seed like this will get away with it. It's just you have to prove that they actually got some benefit, which they were able to do. And so we're back to kind of more intuitive result. I'm also going to say, I was cited in this Monsanto and Schmeisser case for the use of the differential profit. And this was really, there was a Canadian Biotechnology Advisory Committee that had come up with this this list of, I forget how many recommendations, a dozen recommendations about how we need to modify patent law to take account of genetically modified organisms. And there were no lawyers on that committee, and they made all these recommendations, and the recommendations were all, in my view, kind of based on a thorough misunderstanding of the law. And I kind of had a little project for a while. I'm going to write an article on why each one of the recommendations is wrong. But one of the recommendations was there should be an innocent infringer defense to patent infringement for a farmer. And I'm saying, no, there doesn't need to be an innocent infringer defense, because what are the remedies? Let's look, even if you're infringing, what are the remedies? If it really did, if you were innocent, it blew into your field, well, a court's not going to enjoin you from an involuntary action. So there's no injunction going to be granted. And what's your monetary remedy? If you didn't take advantage of the special properties, then I argue the differential profit is the correct approach, and that'll be zero. And so there'll be no monetary remedy either. So I want to make it, kind of clear that this was ultimately, at least from my perspective, not intended as a kind of, the pro-infringer. I mean, I think of it as just pro-sound principles, but it wasn't particularly pro-infringer. It was saying, I was motivated by arguing that we don't really need an innocent infringer defense in patent law. If you're an innocent infringer, you won't be liable to any monetary remedies. And if you're a non-innocent infringer, then you will be liable. And then we don't need to have any, because existing law can take advantage of it, can deal with it appropriately. All right. So that's the Canadian view. I want to talk a little bit about the grain processing decisions, which were some pretty important US cases. And the patented product was this Lodex. I'm just going to call it Lodex. That was the brand name, Lodex 10, low dextrose maltodextrin. So just to back up, Schmeisser, I've argued, yeah, that was actually sound as a matter of policy, but it's still a little counterintuitive here that this seems wrong. They actually infringed, their liability is zero. There's a problem there. All right, grain processing, I think, illustrates why that makes sense. The patented product was low dextrose maltodextrin, and it's, I don't know, it goes in some kind of food substance, goes in cake mixes and that kind of thing. So in any event, the claim specified a descriptive ratio, whatever that might be, of less than 2. But this was, part of the claim. And the defendant says, yeah, all right, we want to get into this market. We know about this patent. We don't want to. They made a first one to infringe. They say, all right, we still want to get into this market. We're going to make another version. They revised their formulation, and it didn't take them much time, so that they had a descriptive ratio greater than 2, right? That greater than sign is the other way around. They thought it was greater than 2, but it turned out they had measured it using the Lane-Enion procedure, and they should have used the Scruel procedure, right? So the point is, they thought in perfect good faith that they were not infringing, and it was wrong, but it was a really technical, it was a claim construction, right? How do you measure the DR2 as a matter of claim construction? And they said, all right, we lose again. And it took them 2 weeks after that they lost to come up with another one that had a formula DR greater than 2 by the Scruel procedure, and that did not infringe. So the point of that is that, this patented technology was nothing very special. It took them literally 2 weeks to invent around it and avoid the claims. And they clearly, but there was that period where they were infringing and they thought they weren't infringing. And that was the period they were seeking damages for. And they said, all right, we were infringing, but obviously, if we'd known that we should have used the Scruel procedure for assessing the descriptive ratio, obviously we could have done that and we could have produced a non-infringing product. So we would have been able to compete equally well, apart from the 2-week ramp up, with a non-infringing product. So the problem here, and this is the twist on the, my first example that seems kind of common sense of the patented grain auger, and you're selling the 2 products. In that case, the infringer is saying, look, I had 2 products actually in the showroom. I could have, maybe my customers would have bought the other one. This one, this Formula 3, was not actually available. So they want to say, not that we had it and would have sold it, they want to say we would have developed it. So clear enough on the facts, they could have developed it within 2 weeks. And the trial judge, and this was, the trial judge says, yes, you would have been able to, and that's appropriate to use as a non-infringing alternative, even though it wasn't available at the time. Now, this went back and forth to the Federal Circuit a couple times, and just by way of background, the trial judge here was Judge Easterbrook, who was at that time on the Court of Appeals for the 7th Circuit, Chicago. He was sitting by designation as a trial judge, former professor at the University of Chicago, leading light in the law and economics competition. Very smart guy, very, very sure of himself, very confident. He said, yeah, this is the rule. They would have been able to compete, essentially nominal damages. Went to the Court of Appeal for the 7th Circuit, and they said, oh, no, blah, 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 you're kind of wrong. They sent it back. And he said, it's really quite funny to read a second decision where he in effect says, clearly you didn't understand what I said, because here's what I said, and no, I didn't make yet that mistake, and I'm saying it again, and have at it. And so then it went back. It was a different panel with Chief Justice Rader actually wrote the decision, say, yeah, you were right. So that was just kind of funny. But the point there, it was kind of counterintuitive to the Seventh Circuit. They thought, oh, this doesn't really make sense. They wanted to send it back. Judge Easterbrook insisted. So in any event, that got established. And the point there is that the non-infringing alternative illustrates that patent really wasn't very important. It wasn't a big contribution. It was really actually easy to make that low dextrose, and nobody actually cared about the descriptive ratio. They just wanted the low dextrose product. It was just as good from the customer's point of view. And so the claimed invention was really nothing very special. And that was clear on the facts. And that's why this gets to the NIA, like why? What's the point here? And the point, this is Judge Easterbrook in the Green Processing, says that by using a non-infringing alternative to assess damages, it enables us to understand the true value of the invention. So what's special about a descriptive ratio of less than 2? If customers won't buy it, and the only way you have your descriptive ratio less than 3 and you're not making the sales, well, then damages are going to be substantial, because there's not going to be a finding that you could have competed equally well. But if the finding is you could have competed equally well with the alternative, then what's the value of the alternative? The value of the alternative to the consumer is the difference between the amount they'd be willing to pay for the product and the amount they would have been willing to pay for the next best alternative. And if that's nothing, then the value of the invention is nothing, and we shouldn't be giving you substantial damages. And of course, that logic about the value of a product is the difference between what you're being offered and your next best alternative. That's kind of your standard approach to the hypothetical negotiation in the reasonable royalty context, is trying to decide what the maximum willingness to pay is. And that kind of caps the value of your license fee, because that's the value of the invention to a licensee, is the amount they're willing to pay over the next best alternative. This is exactly the same hypothetical applied in this context, where we say the value of the invention is the amount that the consumers would have been willing to pay over the next best alternative. So the idea here is the non-infringing alternative establishes the true value of the infringing goods. All right. And this is the same thing that the Supreme Court of Canada said in Monsanto: profits are allocated according to the value contributed to the defendant's wares by the patent. And out of modesty, after the colon there, they cited me. So I was modest and I deleted it, and I'll be immodest and put it in there. So that was the argument as to why we're going to use this non-infringing alternative. Now, obviously, that wasn't really the case in Monsanto, where, well, I mean, it was true if he didn't actually use the seed, if he did use this, but that's just a failure of evidence. And as I say, that was rectified in the next case. So that's now well established in Canadian law that that's the purpose of this non-infringing alternative analysis. Supreme Court, Federal Court of Appeal has said the same thing. I'm going to give you one other, and I will say I was involved in this litigation consulting for Apotex on the bifurcated, not at the liability phase, but at the bifurcated remedy stage of the trial decision and at the Court of Appeal decision. So this was Merck had a patent on a process for making lovastatin. Apotex was able to undercut Merck using a more expensive unpatented process, just because Merck had pumped the price up high enough with its, even though it had a cheap process, it priced it high enough that Apotex could undercut them using an unpatented process. So Apotex set up production with a Chinese joint venture, specified that they needed to use the non-infringing process. The joint venture partner switched to an and they Apotex contracted with the joint venture for supply on the basis that they'd be using the non-infringing process. The joint venture switched to the infringing process because it was cheaper and presumably pocketed the difference. But in the end, it was established that all the product actually sold in Canada, or not all, almost all the product actually sold in Canada was infringing. So, but here in these facts, Apotex says, but look, it's clear that we could have competed equally well with the non-infringing product, because that's what we actually thought we were doing. You know, it was the joint venture that switched without telling us, because they didn't want to tell us, because they wanted to keep a share of the profits. So the Court of Appeal, the differential profit approach in that case, that was a damages case. So Schmeisser had been an accounting of profits. This was affirming, yes, the same approach applies in the damages context, and also gives you another illustration of the way in which the non-infringing alternative analysis reflects the value of the invention. It's Merck, they could have cut their price and undercut Apotex, because if Apotex is using a non-infringing process, it's got higher costs. So Merck still could have taken the market by using their cost advantage to undercut. But then, of course, consumers would have benefited. So the real benefit to the consumer is that cost reduction. And in order to make sure the consumer, in effect, gets the benefit of that cost reduction, we've got to say, well, Apotex, you could have competed using the infringing process, then the fact that Merck was selling product at a much higher price, they're not entitled to that extra profit they would have got by simply keeping you out of the market. All right, so that's lovastatin. Another example here, this one has been example of how it operates is, let's say the patented process is made domestically. So the infringer makes the patented product in Canada for export. So this was the Perindopril litigation. Apotex made infringing product in Canada and exported to Australia. Then during the damages phase, they said, well, all right, we were infringing. And of course, there was always the argument over whether there was infringement validity. They lost at that phrase and said, all right, we were infringing, but we could have subcontracted it to be made in India, where it's not patented, and exported for Australia. And I should say the patentee here was claiming for the profits it had lost in Australia due to the competition from Apotex, on the basis that but for the Canadian manufacturer, the patentee would not have lost its sales in Australia. And Apotex said, no, you would have lost those sales anyway, because we would have made in India, and we would have been able to compete equally effectively. That was accepted in principle in the Perindopril accounting case, although the argument failed on the facts, and I've actually forgotten why, but it was accepted in principle. And Professor Tom Cotter has an excellent recent article on this in this Cardozo Arts and Entertainment Law Journal, essentially arguing that that's the correct approach. Now, yeah, I'm gonna skip over that. All right, so that's kind of our outline of the law, the policy, some examples. I'll hit a few issues then. So I think I'm doing okay for time. Some of the issues that have arisen from the Canadian litigation, and now, as I say, this is kind of regularly applied, but there are about half a dozen leading cases that have actually applied this on the facts. And these are some of the issues that have come up. So one point is that this is often referred to as a non-infringing alternative defense. I hate this because to me it's not a defense. It's simply a method of assessing damages. It's the but-for causation applied to the assessment of damages. And the problem with this defense language is a defense, typically you have to set up certain elements of a defense in the same way that you have to set up certain elements of a tort or of infringement to prove your infringement, while the defense is equally substantive. And the idea is it's kind of some substantive requirement that has some substantive requirements associated with it. And in it particular, so it's been, and this is not super reflected in the cases, but this is my understanding from speaking with counsel who are involved in this kind of litigation, that this is the discussion that's going on, is that there's a sense that there has to be some kind of special criteria for being able to call something a non-infringing alternative. And in part, this is reflected in this statement from the lovastatin damages case, where one of the questions is the non-infringing alternative a true substitute? What does that mean to be a true substitute? The grain auger example. The regular grain auger, well, it doesn't have the high flow grain auger, but it's a substitute in the sense that people will buy it. So from my point of view, there's nothing special about being a true substitute. The question is just, what would you have done but for the infringement? And if the answer is I would have bought this other grain auger, then that's the alternative. But there's kind of an underlying current that there are some special criteria to be considered a true substitute, and that and it's a little nebulous as to what they are, but this is causing some problems. So as I say, it's a little bit nebulous. And we do see it, I think, reflected in the recent Nova and Dow decision of $500 million in damages that is now on appeal to the Supreme Court. And even in that decision, it doesn't come out super clearly, but I kind of think that that's what was driving that decision. The idea that the alternative in that case, it's what they would have done but for the infringement, was a specialized high value plastic, and their alternative is we would have gone back to making regular low grade pail and crate plastic. And the court kind of said, well, that's not a true alternative, so you can't offset those profits. So as I say, that's a little nebulous, but so I don't want to go into too much, but it's a problem, a conceptual problem that's kind of lurking in the background. There's another problem of this concept that a wrongdoer will get a free pass. This is very front and center in the Nova and Dow litigation, where, in my view at least, the federal court, Court of Appeal just basically departed from but-for causation, and they were pretty explicit about it and said, no, we're not going to do differential profit, and there's a question of departing from precedent and Supreme Court and all that kind of thing. But the question is why, and it's pretty clear in the case that the court is worried about this need to deter the infringer, and my counter argument to that is damages and accounting of profits, these standard monetary remedies they're not punitive, and we shouldn't be thinking about deterrence. We should be thinking about valuing the invention. We need to provide an incentive for the patentee to come up with new and valuable inventions. We should not be providing the patentee to come up with useless inventions that don't actually provide any benefit to the public, but then they can reap a lot of, $500 million in damages from the because of vagaries in the way that the remedies are calculated. And in particular, you need to avoid a chilling effect. So a lot of the time, we don't know whether there's going to be infringement or not. We don't know whether the patent is valid. An infringer who challenges a patent and ultimately invalidates the patent is really doing a public service, because there's a patent out there, it's keeping prices high, even if it's invalid. If the infringer who comes along and says, yeah, I'm going to sell something, I think your patent is invalid, I'm going to challenge it, I'm going to infringe and challenge the validity. And if they win, that's not just to their benefit, it's to everybody's benefit. So we don't want to dissuade, and often there's a lot of uncertainty as to whether or not the patent is valid and whether you're infringing. And if every time you bring an action and you happen to lose, you get hit with what are essentially punitive damages, there's going to be a chilling effect, and that's the detriment of the public, who is now burdened with the excess prices from invalid patents. So this was recognized by, this is Justice Gauthier in the Lovastatin damages case, recognizing this need for perfect compensation. The balance at the heart of the act requires perfect compensation, and that is to reflect the value of the invention and not merely the value of the patent rights in the sense of being able to exclude competition, but only that to the extent that it reflects the value of the invention. So that's my view, is this is not about deterrence, it's about perfect balance, perfect compensation that preserves the patent incentive while avoiding any chilling effect. And a lot of the problems and the resistance to the non-infringing alternative is pretty clearly driven by a kind of sense that patent infringers are bad, morally bad. And to my mind, that's just not, it's not true. A, it's business, but B, there's a real public service to challenging an invalid patent. All right, so we'll see how that goes. That's my response. We'll see what the Supreme Court of Canada has to say on that one. Oh yeah, and the other part of the response is, we do have punitive damages. If they really are bad, they've intentionally copied with the in the knowledge that the patentee is a little guy, and I'm going to steal your invention, and I know it's valid, and I know I'm infringing, and I just don't think you're going to be able to afford to litigate. Yeah, that's bad. Well, we got punitive damages for that. And that's the kind of context where punitive damages actually are awarded in Canada. We don't need to make standard compensatory damages into a punitive mechanism as well. A little bit of burden stuff. This is pretty well established, not very controversial. The patentee in a damages case has to prove lost sales from the infringement. Then if the infringer wants to say, I would have competed with a non-infringing alternative, the burden is on them to prove that. The patentee can, if they can't prove it, then we just go back to they would have left the market hypothesis. Sometimes a patentee will come along and say, all right, no, you wouldn't have done that. You would have done this instead, which would have competed, but not as well. In that case, the burden is on the patentee to prove that. So basically, it's pretty straightforward that in effect, anybody making a particular argument that this would have happened that's outside of the baseline has to carry that burden. So I won't go on about that. All right, we do have a kind of could and would test. Every doctrine needs a test. This is actually kind of 4-part test developed in the Lovastatin damages, but now is generally kind of conceived of as being a 2-part could and would. Could the infringer have sold the non-infringing alternative? Would the infringer have sold it? The could branch goes to technical considerations. Do you actually have a supply? You know, like you say you have a non-infringing product, a process. Could you have ramped it up? You know, could you have developed it? The grain processing, they were able to show that they could have developed a non-infringing process by the fact that they did develop a non-infringing process in 2 weeks. But that's the kind of question. Could you actually have developed a non-infringing process? It's clearly not enough to say we might have developed one. Could you have gotten marketing authorization? You know, so that's the kind of thing in the pharma cases. Yeah, you know, generic, you would have been able to use a different process, but you wouldn't have been authorized. You would have had to do clinical trials, whatever. So that's the could branch. It's these technical considerations. The would branch goes to business considerations, and in particularly, would it have been profitable to compete with the NIA? Using your NIA. So the generic might say, you know, it wants to resist damages. It says, I would have been able to compete with this non-infringing alternative, and therefore my damages would be reduced. Well, what if they wouldn't have done that because they would have made a loss? And from the infringer's point of view, in fact, they would have left the market entirely rather than compete with the NIA, because if they competed with the NIA, they would have lost money. So if that's true, they can't come in on the damages phase and say we would have competed with the NIA and reduce our damages when the truth is, in fact, you would have left the market. So that's the would branch. You know, the most basic is its business considerations, and the most basic being, would it have been actually, yes, you could have launched a non-infringing process, but if you would have lost money and if it would have been more profitable to simply leave the market, then that's what you have done, what you would have done. I mentioned this. Oh, I can't remember if I mentioned I didn't mention the instantaneous availability. For a little while, there was an instantaneous availability requirement, similar to what we took a look at in grain processing. That was relaxed later on, so that's not really a hurdle. We're more on a grain processing kind of scenario. One thing that's been causing some issues is an objective versus subjective test. What if the defendant would have behaved irrationally? What if the evidence is to the effect that the defendant would have entered the market with an unprofitable product? Well, if we say but for causation, the difference between the actual world and what in fact would have happened, you might say, well, with an irrational defendant, irrational things would have happened. And if they in fact would have entered with an unprofitable product, then we got to go with that, and your damages are going to be reduced accordingly. But the Canadian courts have not said that. So this is Justice Gauthier again in Cephaclor. The Cephaclor damages litigation said no, because the problem with that is really this NIA analysis is intended to assess the real value of the patented inventions. That doesn't depend, the value of the patent invention doesn't depend on the subjective motivations of the particular people in the industry. So it has to have been an objectively economically viable substitute at the relevant time. Now, I think that's basically right. I will say that you can kind of debate that, because the actual value of a patented invention is the money you actually make in an actual market. And, you know, the fact is economic theory and rational actor theory is kind of nice, but actual markets have irrational players. And if you would have made money off irrational players in the actual market, why shouldn't that be reflected in the damages calculation? In any event, I'll say that one is, you know, it's a subjective objective debate. There's a legitimate view on both sides. So far, the Canadian courts have come down on the side of an objective indicia, an objective requirement or objective test. But there's a real evidentiary issue. You know, how do we know what's objectively economically rational? And in effect, in Canadian law, there's a presumption that the business decisions the parties would have taken are rational. So this came up in, it wasn't Sepulchre, I think it was Perindopril, anyway, it doesn't matter. Yeah, this came up in the Perindopril litigation, which is we would have manufactured in India. And so the evidence was that they could have manufactured in India. They could have made a profit if they, so technically they could have manufactured in India. They would have made a profit if they would have manufactured in India for sale to export. But the evidence was that Dr. Sherman, who was the directing mind of Apotex at the time, had a subjective, I'm put quotes, subjective preference for domestic manufacture. And so then the issue is, and then this one was kind of ironically the patentee arguing for the subjective test on the basis that in fact, no, he would have still infringed, and so we can't take into account the Indian alternative. But the better argument, rather than, sorry, not the better argument, but we can argue over whether you have a purely subjective or purely objective approach. But I think there's an important twist as an evidentiary matter, is that the actual preferences of an extremely successful businessman like Barry Sherman, you've got to think that he knows what he's doing. And so even so, if the evidence is that he would have manufactured in Canada, you've got to think that's irrational. It's not just, he didn't become a billionaire by being a Canadian, just by patriotic sentiments. So arguably those kind of business decisions probably reflect objective preferences that are actually difficult to prove. So things like he prefers to manufacture domestically for tech transfer requirements or for quality control requirements and so on. So I kind of think that's rather than arguing over the objective subjective approach and trying to say it's strictly subjective or strictly objective, a middle ground that I think solves a lot of the cases is just to recognize that subjective preferences of business people often reflects, is very good evidence of what's objectively rational, and maybe actually better evidence of objectively rational tests than, some ex post evidence of forensic accountants. So I'm running out of time. Am I good here for a couple more minutes? Go ahead, Raya, sorry. All right. So this one's a really important one. The infringer has to prove this, not that they would have used the non-infringing alternative. On what basis do they have to prove it? So it's now established in Canadian law that they have to prove it on the balance of probabilities. We would have been able to develop a non-infringing process with a 60% probability. All right, if it's 40% probability, you can't use that as a non-infringing alternative. So that's the rule in patent law. That's in tension, at least with Canadian general law, tort law, which is that hypothetical events, what would have happened in the but-for world, are given weight according to their relative likelihood. So if there's a 40% probability you would have been able to develop a non-infringing alternative and compete with that, and a 60% probability that you wouldn't, then the damage should be assessed as, you take your damages without the non-infringing alternative, multiply by 60, take the damages with the non-infringing alternative, multiply by 40%, add them together. So that the hypothetical events, how the but-for world would have unfolded, is assessed on the basis of probabilities rather than, so relative likelihood rather than balance of probabilities. So this is a problem. Like we do have so the Court of Appeal wasn't off on a frolic of its own. There's a particular line of cases stemming from negligent misrepresentation, as it happens, from the Supreme Court, more or less saying that this but-for world is constructed on the balance of probabilities, and that's the line of authority that the Federal Court of Appeal went with. There's kind of a tension with our general tort law, and obviously it's big money difference, right? There's a lot of money at stake. You know, if you got 40% probability, we would have been able to compete equally well with a non-infringing alternative. You know, that's a 40% reduction in your damages, and if you have to get over the 50% probability to establish that, you know, it makes a lot of difference on both sides. So I don't have an opinion on that at this point. I'm just going to flag that as a real problem. You know, we have the kind of doctrinal problem in Canadian law as to, like, is there a split in the Supreme Court? What's going on? Then there's a kind of policy problem as to which is better as a matter of policy, relative likelihood, balance of probabilities. I don't have an opinion on either of those. I'll just want to flag that as this is a real live issue that's been pretty important and a lot of money at stake. What if the alternative is patented? The Supreme Court of Appeal had said, well, if the alternative is patented, it's not a true alternative. So that's kind of, as a matter of law, it has to be unpatented, which kind of makes sense if you would have been infringing the patent of some other brand company, for example, that wouldn't have licensed to you, but not quite as obvious if you could, you know, if the other patentee routinely licensed. You know, in fact, you would have been able to just go to the other patentee, ask them for a license, and we can prove that they would have said yes. We're still going to ignore the patented alternative. I'm just going to flag that as an issue. It's not clear that despite this statement, it's not clear that in a case where that even the Canadian courts, in a case where the patented alternative was routinely licensed, whether that would be excluded. I'm just going to flag that. The last one here, and, you know, down to 4 minutes, but the question of fixed cost. It's obviously a very difficult question. It's been addressed in UK law, Australian law has that Dart Industries leading case, but a really tough question, particularly in an apportionment case or in an accounting case where you've got infringing goods were made in a factory, the lights were on, and the factory was also producing non-infringing goods. Lights were on the whole time. Can you deduct some part of your the overhead costs for things like lighting from the costs? Can you add some of those costs to your costs of production, and thereby reducing your accounting costs that you have to disgorge, or do you have to just, is it only marginal costs, right? So the question is, are your costs on an accounting, are they just marginal costs, or does it also include some proportion of your fixed costs? So a traditional view, one view has been to develop some kind of apportionment, but then the basis is, yeah, fine, some part, what part, very difficult conceptually to work out. And all I'll suggest here is that the strict application of but-for causation provides a solution to this problem. So I'm just going to end there. And I've got a long blog post about that. So there we go. All right. So 1 minute for questions.
Great. Thank you very much. This was really fascinating. So what happens when the infringer and the patent owner are not operating in the same markets, and the infringer is not cannibalizing on any market share from the patent owner? And what happens if, well, the patent owner, the patentee, is an NPE and isn't operating on anything? So what do you do then if there's no loss in markets because an NPE?
Okay, so the question is when the NPE number.
What if, for example, you produce coffee machines and you're the patentee, and you're being infringed by someone who actually used your patents not for a coffee machine, but for something you're not doing anyway?
Right. Yeah. Right. So, I mean, the standard answer in the Canadian law is that you get a reasonable royalty for that infringement, but the infringer can resist that reasonable royalty in the same way by saying, well, I wouldn't have paid any royalty because if I would have known, I would have used a non-infringing alternative. So the standard view is that apart from the whole NIA defense, the patentee is entitled to a reasonable royalty on the idea that, okay, you're making coffee machines, I used it for something else, but presumably my use of your patented invention gave me some advantage in my own market, even though you weren't actually selling into that market, and so I owe you a royalty. But you can still apply the non-infringing alternative to say, no, I wouldn't have agreed to a license because I had an alternative that was just as good that I would have used instead of licensing.
If it's a patent assertion entity that's not producing any, it's not using the patents to produce anything, is there any answer to that question already, how you would measure that?
Yeah, so I think that that's basically the same. It's going to be the same as for the licensee, is that now they're never going to be able to get lost profit damages, obviously. There's a question that's kind of totally aside from that in Canadian law as to whether or not an NPE would be entitled to an accounting, right? So patentees are routinely granted an accounting in Canadian law, but it's clearly discretionary. And when we get to the point where an NPE wins, because we haven't had that kind of litigation, if an NPE requests an accounting, will they get it? That's a live issue. We haven't faced that issue, and I think there's, so if they're seeking, so maybe they're confined to damages. If they're confined to damages, it's going to be reasonable royalty damages, and then we've got the non-infringing alternative defense or analysis popping up again.
What about the relationship with French law?
Yeah,
and the whole drama in Quebec, because they are in a different world somehow. How do you guys handle that as a country? You know, that majority of the country does the Anglo-Saxon English common law, Scots law, and the others are like following France. How do you bring that together?
So in patent law, it's all federal court jurisdiction, and even the cases that come out of Quebec, if they come out of Quebec, if they go to the federal court, it's all the law of federal court. And I mean, the law of the federal court is based on these common law principles, but really ultimately it's based on the statute, the statutory provision that entitles the federal court to award damages and accounting of profits and monetary remedies. So the actual, even though the court draws on common law principles, it's not strictly applying common law and developing in awarding those remedies.
Interesting. There are 4 questions, 3 chats. Okay. Oh my God, people, these are long questions. Okay, Judith, the patentee in Perrin-Dauprel did not argue for a subjective approach. The patentee argued that the business factors are considered in the wood component are not limited to profitability only. It sounds like you would accept that the wood is not limited to profitability while remaining objective. Ulla. Can you read it? Because I think I didn't read it very well. So maybe if you read it yourself, you have better.
Yes. Right. Yes. So I basically agree, and I will say that's the Perrin-Dauprel litigation. I found the first instance judgment kind of difficult to understand what the arguments were. And basically I wrote a blog post on it criticizing that, went to the Court of Appeal, and the Court of Appeal, and basically once I read the Court of Appeal decision, I realized I'd misunderstood the trial decision in the first place. So I totally accept that issue that the patentee in Perrin-Dauprel didn't argue for a subjective approach. And so I didn't want to, I was more using that as an example of the debate between the subjective and objective approach. And it's fair comment that it's wrong to say the patentee in Perrin-Dauprel was specifically arguing for subjective approach. Now, the business are not, yes. So I really appreciate that. Yeah, I like that. The patentee argued the business factors considered in the wood component are not limited to patent profitability only. I think, I hope that's consistent with what I just said. That's a really nice way of putting it. And that was kind of what I was saying about, Barry Sherman. You got to kind of presume that whatever decisions he made were made for sound business reasons and not just profitability, and the idea that profitability is, we can go and say, here's the contract cost I would have got in India, but the mere fact that you could have made it for X dollars in India doesn't mean you would have done it there, because there are a lot of other things that go into it, like quality control, tech transfer, and so on. So yes, I definitely agree that the wood is not limited to profitability. Yes, 100%. And while remaining, and yes, you can do that while remaining objective. So I totally agree that an objective approach to the wood branch includes factors other than profitability, 100%. That's a good way of putting it. The only caveat is I'm still a little bit on the fence about subjective versus objective approach. If you, so I like that synthesis. It's objective and consider factors other than profitability, 100% on that. But I'm still kind of, maybe a pure subjective approach would work also. I don't know.
Then there's, I thought we wouldn't have questions. Sorry about that. Like there's another question from James who's saying, if there's a non-infringing alternative, there are lost profits, but what about a reasonable royalty? Fact is, the infringer did use the patentee's property. The patentee was harmed and the defendant benefited. So no lost profit, not lost profit.
Yeah, so those not, so where it's a reasonable royalty case, so it's if so this is, we're talking about damages. If the patentee can't prove lost profit damages, basically they're entitled to reasonable royalty. We use a hypothetical negotiation approach, just like, essentially the same as the US. I mean, I'm not going to swear it's the same in every particular, but essentially the same as the US hypothetical negotiation approach. And the NIA comes into play in that hypothetical negotiation approach, in that the maximum willingness to pay turns on your next best non-infringing alternative. And so that in effect, the non-infringing alternative approach comes into play very naturally in a hypothetical negotiation, because that's the whole question. Your maximum willingness to pay turns on your NIA, and so what is it? So that hypothetical just flows right in there.
I don't know, there's still endlessly long comments.
Oh, and I like this question about the hypothetical negotiation where an infringer infringes on multiple weak patents and would look to offset one against the other. So I think that goes back to this point about the where the alternative is patented, right? And we saw Justice Gauthier saying, well, it's got to be a true alternative, and a true alternative can't be patented. And I don't know about that, right? So this, because if you do the economic theory, if you got two patentees, they're both monopolists, what kind of competition do you see? Could be Bertrand competition, could be Cornell competition, depending. And my understanding is if you got two monopolists, what kind of competition do you actually see? It could be price-driven competition. It could be quantity-driven competition. It's going to end up with different price levels. So all I'm going to say about that one is, yeah, it's a real problem. That's a very tricky problem, and I don't have a good answer. But that's one of those ones. The patented alternative, it's conceptually really interesting. Yeah.
Wow. And then I think the best comment is, this was just, oh my God, people. I'm so sorry. I said to you, just use the hour because there won't be comments. I didn't think you would create so much in terms of reactions. Can you comment on why the NIA defense is not a factor in the US for pharma cases?
No.
Good.
I don't
How
know.
do you apply NIA in Brazil? Could you comment? Probably also not, right?
Yeah.
Brazil?
Well, okay, the US, does the NIA, do they really require the NIA to be available at the commend? Oh, yes. All right, so the US law is they've got this issue about the hypothetical negotiation. Maybe that's the hypothetical negotiation taking place at the date of first infringement. So to the extent you're talking about that, I think that's wrong. I have that they shouldn't do that. I have an article with Tom Cotter, Florida Law Review, I think it is, called a new framework for something or other, reasonable royalties or damages, where we specifically argue that the date of the negotiation, we argue in effect that the date of the negotiation should be taken to be the date of first infringement, but taking into account ex post information. So yeah, so that, but I'm not sure that the US actually requires the NIA to be available at the commencement of infringement, because that was the issue that was settled in grain processing. Now, grain processing did use that. It was 2 weeks was effectively instantaneous. And that got picked up by an Australian court who said, oh yeah, the NIA is only available if it's available instantaneously. But that was a misreading of grain processing, because grain processing really just said it was an alternative. And on the facts, it was available within 2 weeks or 3 weeks, whatever it is. And they just kind of offhand comment, and that was practically instantaneous. Well, at least that's how I read it. I don't read grain processing as requiring instantaneous availability. I know an Australian court did read it that way. I think that's a wrong reading.
And then we had the best comment of all, which was like, thank you for this great talk.
Thank you.
So I really thank you very much, Professor Siebrasse, for this excellent presentation. I learned a lot. This was really insightful. I really, really appreciated your insights. Very, very valuable and interesting. Thank you for taking the time to present. You see, our audience was very faithful. The majority of people stayed with us. Thank you all. Thank you also for joining us, Christina. Hope you come next time again. Next month, we have Professor Kotter speaking about the same questions in a US context. And then we'll have a talk from Israel on the question of tech transfer and patent valuation from the Weizmann Institute. And we're close to our conference already. Yeah, be with us. Join us again. Thank you very, very much. This was really a good talk. Thank you very much. Have a lovely day.
Thanks for everyone who joined.
Bye-bye.